So this specific benchmarking solution was originally valued at $47 million, but then increased to $48.8 million. And only one contract of the 19 provided any justification as to why McKinsey was the only company able to perform the necessary services. So this means $43 million was paid to McKinsey without the proper documentation.
There is an element of fraud in relation to the Government of Canada. Yes or no, sir?
You always ask me these difficult questions.
This guy's garage. Like and subscribe.
My office examined the procurement files of 32 McKinsey contracts and one National Master Standing Offer, or NMSO, issued to McKinsey through competitive and non-competitive procurement processes to assess their fairness, openness, and transparency and their compliance with legislation, regulation, policy, and procedural requirements. PSPC was the contracting department for 23 contracts and the National Master Standing Offer. The review did not include contracts awarded by federal organizations that are not in my mandate, for example, contracts awarded to McKinsey by Crown corporations. With regards to competitive procurement practices leading to the award of contracts, my office identified instances where procurement strategies were changed to allow for McKinsey's participation in the procurement process, creating a perception of favoritism towards McKinsey. In total, there were 5 recommendations made by my office, which were all accepted by the implicated departments. It should also be noted that PSPC accepted most of the findings in the report but took issue with some observations. I would be pleased to discuss all of these matters with.
Thanks for your attention. I would be pleased to answer any questions you may have.
I see that the 4 lines of inquiry, the first one being competitive procurement practices leading to contracts awarded to McKinsey, yet 78% of McKinsey contracts were sole sourced, and 59% of the contracts you reviewed were sole source contracts specifically under a benchmarking service deal catered towards McKinsey, correct?
Can't validate the statistics, but yes, it sounds accurate.
Thank you. So this specific benchmarking solution was originally valued at $47 million, but then increased to $48.8 million. And only one contract of the 19 provided any justification as to why McKinsey was the only company able to perform the necessary services. So this means $43 million was paid to McKinsey without the proper documentation, a theme we've seen repeatedly, unfortunately, across this government. Do you believe it's because the departments favor McKinsey as a company in comparison to others that perform similar services?
So, Mr. Chair, thank you for the question. I think in totality what we concluded, in addition to the NMSO, which you well described, we found instances of favoritism towards McKinsey. Now, the one counter to that is in the NMSO creation, as we reported in the report, there was also the creation of 4 other national master standing offers with other entities, not McKinsey.
So then why do you think it was that departments were changing their requirements to allow for McKinsey to bid on contracts that they were not originally eligible for?
Mr. Chair, thank you for the question. So again, where there's a lack of documentation, we simply allege the facts, right? And I don't know if you recall, but at my previous testimony, I started to talk about negative inferences. At what point do we make negative inferences associated with the lack of documentation? And this report starts that trend of negative inferences where we allege the facts, but ultimately came to a conclusion that in sum, there was favoritism towards McKinsey.
And what evidence did you find that encouraged this favoritism from government departments?
Well, so you've cited 2 examples. So one was in the change of procurement strategy. What we saw was there was a procurement strategy being contemplated, and then it was only through the realization, whether it be directly with McKinsey or through the contracting authority, that they would not be qualified to participate in the process, and therefore there was a reconsideration of the process. Now, could there have been additional factors in addition to that fact alone? Absolutely. And we're not discounting that, but we're simply saying that did happen, and the contracts were in fact awarded to McKinsey. And I just will say one more thing. In addition, we found a lack of documentation. So other ways that we could kind of walk back our findings, where if we saw documentation which would explain why some of these decisions were taken. And you'll note in the report there was a lack of information explaining why there was a change of these decisions or procurement strategies.
Interesting, very similar to the Auditor General's findings around ArriveCan, that she was unable to actually determine the actual cost of ArriveCan as a result of missing documentation. The only contract that received a justification was challenged by PSPC. I believe the term that they used specifically was take issue. Words were take issue, because it was not accurate and did not justify the exception. Did ESDC respond with the proper justification, or did they maintain their original justification?
The justification that's cited in the report is the only one we saw. We didn't see a subsequent that might have been previously adjusted, but what we saw in the file is what's reflected in the report, and it provided inadequate justification in our view.
Thank you. To approve the contract, PSPC had the Minister of Procurement personally sign off on this $5.7 million contract. Is that correct?
Yes.
Which minister signed off on this contract?
Minister Tassi.
Thank you. Is it standard practice for a minister to personally approve a contract that their own officials challenge?
So in this circumstance, we did look for the rationale as to why the minister signed off on this specific contract. So there is an internal delegation instrument, I believe, within the department that, based on the dollar value associated with the contract, required minister approval.
What justification would a minister possibly use or to have to sign off on a $5.7 million contract? Can you think of a justification that would be legitimate for where a minister could personally override their officials and sign off on a contract? Have you seen this before? And what would, if not, yes, when? And if not, what kind of justification could possibly be used for this type of authority?
So I will say the implication of any political actor in a procurement process is not ideal, because it puts the political actor in a difficult position, whether approval or rejection of the recommendation to ultimately enter into the contract. That being said, the signature was provided based on the recommendation, and it was in line with the required delegations within the department. Beyond that, we have no additional insight specifically why that was done other than the value of the contract.
You've looked into one company and you found these problems with procurement, and you've extrapolated from that and suggested that there's a systemic issue. What would need to be done to confirm your suspicion that there's a systemic issue with the way the procurement system is being used?
Well, Mr. Chair, the difficulty in answering that question is it's not a specific issue, it's multiple systemic issues, right? And so I do think, and I've used this terminology internally, but I'll share it, I do think the time is now to act. We really need to reconsider federal procurement in its totality. I know it seems like a pretty dramatic thing to say, but I think I've been in this role for over 6 years. I think we've done a great deal of foundational work in terms of what we've seen in the landscape, and I'm fearful that if I don't start acting in a more aggressive manner, significant changes will not come. And I don't think Band-Aid solutions are the answer. I think there needs to be significant rethinking as to how federal procurement is done.
I'm going to share some of the comments of my colleagues in terms of some of the overlap between McKinsey and Government of Canada strategies, also known as GC strategies. And in terms of the focus of the documentation, which in most cases on both sides of the equation were often missing, incomplete, altered after the fact, it really begs the question, and this is something I get continuously and daily from constituents from all across this country, right, is who is actually responsible for this? It's one thing for us as parliamentarians to expose the rot and the corruption in this government, in this broken procurement process. But where are the consequences? So that's going to be the focus of my first round with you. And the consequences, in my view, ought to be criminal in nature. Because you have a mandate Ombudsman. I know you do. You mentioned that during your last appearance at OGGO, that if you uncover elements of criminality, and I believe your threshold is a mere suspicion of criminality. Am I correct in that assessment? A mere suspicion of criminality?
So there is nothing formal in either the legislation or regulation in regards to criminality.
Okay.
However, that being said, if we were to see something that would give rise to a suspicion of criminality, we would refer that to the RCMP.
Sure. And your threshold is the lowest rung of the ladder in terms of ultimately until you get a conviction. There's suspicion, then there's reasonable and probable grounds by a police service, then there's proof beyond a reasonable doubt by Crown attorneys, and ultimately a conviction. So a suspicion is a very low threshold. I'm looking at literally the same sort of criminal charges as it relates to McKinsey as the Government of Canada strategies, who the RCMP have confirmed and have raided his house a couple of weeks ago. They're looking at 2 counts. Fraud under Section 380 of the Code and forgery under Section 267 of the Criminal Code. So I know that you may not be comfortable in answering this question, but I'm going to put it to you in any event. Do you feel, given your review of McKinsey and the irregularities and the strong presumption against a favoritism towards McKinsey over any other contractor, that there is an element of fraud in relation to the Government of Canada? Yes or no, sir?
You always ask me these difficult questions with only yes and no options.
If it's not a yes or no, I'll allow you to expand.
So I would say no in this circumstance. What we did see is we saw a bunch of different reference points across different departments, and that's why you see in our conclusion we say in some. Right? So within any given department, we didn't see 10 examples of favoritism, right? The only example of communal favoritism, I would say, was in the creation of the National Master Standing Offer, right? It offered an opportunity to contract in a unsolicited way, so where it's directed to McKinsey on a repetitive basis. And so that would be what I would identify as the singular most problematic aspect of this review.
Are you familiar with the definition of fraud under the Criminal Code?
Yes.
Okay. Everyone who by deceit, falsehood, or other fraudulent means defrauds the public, in this case the taxpayer, of any property, money, in this case taxpayer funds, or valuable security or any service, if it's over $5,000, proceeding by indictment and imprisonment for 14 years. So favoring one particular company, allowing them to egregiously break the procurement rules in non-compliance of numerous statutes, numerous regulations, numerous policies, and in fact the PSPC themselves published a document calling Doing Business with the Government of Canada, where they highlight openness, transparency, and accountability. In all those circumstances, do you not see a low threshold case of making out that the Government of Canada, through the PSPC and other departments, are defrauding a taxpayer by favoring McKinsey over other legitimate vendors?
Right. And
Could an argument not be made, sir?
And that I have to ask to be a yes or no, because we're out of time.
could an argument be made? Yes. Did we see it? No.
Thank you.
Thanks.
Your report talks about favoritism in terms of the government's treatment of McKinsey, how they favored McKinsey, how they structured systems in order to give contracts to this favorite consulting company of the Prime Minister. McKinsey benefited from this favoritism. And based on the previous work of this committee, it's clear how this happened. Dominic Barton was brought in to chair the Prime Minister's Growth Council at the same time as he was the managing partner at McKinsey. McKinsey analysts did so-called pro bono work for the Growth Council. Andrew Pickersgill, who ran the Canadian operations, supplied the analysts to do the pro bono work. But while he was supplying McKinsey analysts to do supposedly helpful pro bono work for this Growth Council that was chaired by Dominic Barton, he was also selling to the government. And so you have this process where Prime Minister Justin Trudeau and Dominic Barton are kind of making this connection at the top between McKinsey and the Government of Canada, and then that is clearly filtering out over time throughout the whole system, where the connection at the top was shaping and impacting the kind of procurement that was happening across government to work to the advantage of McKinsey. That led to the establishment of the National Master Standing Officer. I want to ask, just in terms of the analysis you did, about specific individuals involved and what roles they played in getting these things established. So could you speak to Dominic Barton and Andrew Pickersgill, for example, and where they showed up along the way in terms of looking at how this favoritism manifests itself?
Mr. Chair, thank you for the question. So in our review, those names, to my knowledge, did not come up. I'll look to Derek just to confirm, but my belief is that those names did not come up.
I can confirm that Dominic Barton's name did not appear. Andrew Pickersgill, I'd have to go back and review their documentation, but I don't recall seeing that just off the top of my head, but I can come back to you with that information.
Okay, if you could provide some follow-up information in writing about some of the specific individuals. I'm not at all surprised in the sense of Dominic Barton, because I see that connection having been made at the top between the Prime Minister and him, but the selling process happened by Andrew Pickersgill bringing in these analysts. It was the relationship that happened at the top between the Prime Minister and the leadership at McKinsey that then allowed this favoritism to take place. We know as well that there's been a lot of kind of interplay between senior Liberal offices and McKinsey. There's a former member of Parliament in the government caucus that was a former manager at McKinsey. We've had former staff members from the government go to work for McKinsey. What kind of information were you able to identify around sort of political involvement, decisions made by ministers, by ministerial staff that were part of this sort of broader culture of favoritism for McKinsey?
Mr. Chair, thank you for the question. So in the report, we found one example of where a minister approved a contract. It was an ESDC contract. I believe the question came up before you entered the room, but essentially what happened in that circumstance was it was as a result of an internal delegation document within the department that required that contract due to the value to go to the minister for approval. So that was with Minister Tassi for approval. But that would be the only example in our report where we saw any action on the part of a political actor.
Okay, thank you. One of the other issues that frequently comes up with McKinsey is questions of conflict of interest, how McKinsey works for governments and then also works with people who deal with governments. For instance, they work for health regulators, and then they've also famously, tragically worked for certain manufacturers of opioids. In your work, did you see clear instances where they were doing work, for instance, for Health Canada, for other entities in government, where they were also working for companies that the government regulates? I appreciate, part of the difficulty is they have not been willing to give even this committee a client list when requested. But were you able to identify instances of those kinds of conflicts?
Mr. Chair, thank you for the question. So I can answer no, but that's because we weren't looking for that specifically.
Well, just in the time I have left, I just reiterate how important it is, and I think there hasn't been the agreement that I would have hoped for in the past, but how important it is that this committee gets the documents that it had previously requested. There previously had been agreement to order, and we hadn't been able to get in the past.
In your evaluation, did you find political interference in those contracts?
Mr. Chair, no, we did not. As I mentioned before, there was only one instance in the review that we did where there was intervention on the part of any political actor.
Okay.
Thank you very much. I wanted to go back to the non-competitive contracts that your office reviewed that were missing conflict of interest declarations from those who reviewed the bid submissions. Something that we've really been focusing on, I think, at government operations as well as public accounts, the aspect of the conflict of interest. So we learned a couple of weeks ago that 38% of public servants who declared a conflict of interest were determined to be in an actual conflict of interest. How concerning is it that this number is already high, yet we seem to be missing multiple conflict of interest forms in many contracting instances?
Thank you, Mr. Chair. So obviously, as the member rightfully points out, the Conflict of Interest Declaration is a seminal document, particularly for evaluators. So I believe the statistic you provided was in general, but this is specific to the evaluation of proposals, where I would argue it's even more important to have these declarations on file, and also to bring awareness to the issue. So this is a conversation we had in previous reviews as to whether conflicts of interest would need to be completed by all participants in an evaluation, including public servants. And we've strongly advocated that, yes, all participants in an evaluation should complete a conflicts of interest declaration as a participant. So the fact that they're missing is problematic, absolutely.
We saw that the Department of National Defense has contracted a total of $29.1 million with McKinsey, also noting that they had the greatest number of contracts as well, a total of 12 out of the 19. That's a significant amount, almost 2/3. But we also learned over the past few months that another major contracting firm with defense, known as Dalian, back to my original question, has received millions of dollars from this department and even started working with them while the owner of Dalian, their company, continued to sign the contracts. In this instance, there was no conflict of interest form signed. Due to McKinsey's favored nature, do you feel that there are numerous connections that have led McKinsey to make $29 million from this department? Defense specifically.
So, Mr. Chair, unfortunately, I can't answer that question in terms of the connections. What we saw, we reported out on in the report. In terms of any connections made behind the scenes, I can't speak to.
ESPC stated that they took issue, I used that phrase in my first round, with the assumptions and interpretations of your report, as they were not the same as their department. Do you think a department can simply state their own version of events if they have not bothered to provide any evidence to support their claims?
Thank you, Mr. Chair. So that was the nature of our discussions with the department. We certainly believe that the version depicted in the report is accurate. In terms of any assumptions made, they were made only based on the facts that were provided. So if there was a fact provided and no fact provided on the other side, then I think we were safe to make the assumptions that we did make. So there were a number of instances where we had discussions with the department to understand their perspective, because at the end of the day, what we're trying to achieve here is factual accuracy, which is why we engage with the department. First of all, it's required by way of the regulation, but second of all, we want to make sure that the report accurately reflects the facts. So if there are facts that are wrong, we want those to be corrected before we finalize the report. I think the issue that the department was having was any inferences made as a result. So, a conclusion made on what they saw as unrelated facts, and we saw them as related.
Do you think it's respectful of your work to have a department push back on what you find?
Mr. Chair, absolutely. I feel it's within the department's purview to put forward their view, but then I would implore them to document their view in the future so that when they come forward with what actually happened, that it's reflected in the documentation, as opposed to after the fact surmising what may have happened.
Although, I think that's my time. Yeah, thank you very much, Chair.
I'm wondering to what extent the pandemic broke the procurement system, or whether the systemic issues that you are seeing pre-existed and were simply accentuated by the conditions of the pandemic.
Mr. Chair, so thank you for the question. I think if you look back at reports dating back, like I said, over a decade, you'll see that they still resonate today. And that was kind of the starting point when I started in this role, was to look back before looking forward. And one thing that I noted was where our office collects data sets from a number of stakeholders, the issues that we see are repetitive in nature. We create what we call a top 10 list. And that top 10 list is pretty static year over year. And it was disappointing to learn that, the same issues permeate. So we said we wanted to be part of the solution. And that's why we started that 5-year review plan to look at exactly those top 10 issues across the 3 LOEs. So we plan to publish that 5-year report shortly. I don't think you'll be surprised by any of the findings in the 5-year report. Many of them have been discussed. But it's, again, indicative of these are the same issues that we're seeing. Now, I will say that we've seen significant changes in recent years in procurement, the move towards e-procurement. What changes that will amount to are yet to be seen. I think in the early days, I was very optimistic that could produce very positive results. I wouldn't say I've lost that optimism, but I wouldn't say that I would put all of my optimism in e-procurement. Sorry.
If I could, Mr. Chair, just to say it's pretty troubling that the same issues have been coming up for a decade and the government hasn't managed to fix them. I think that's something that should worry all Canadians.
A fair comment. Mr. Brock, please.
Thanks, Chair. Mr. Yeglich, we finished off my first round discussing fraud. I want to talk now about forgery under Section 366 of the Code, which is defined as anyone who commits forgery by making a false document knowing it to be false with intent. Upon conviction, could be looking at a prison sentence of 10 years. Making a false document is defined in the Code to include altering a genuine document in any material part, making a material addition to a genuine document or adding it to a false date, making a material alteration in a genuine document by erasure, obliteration, removal, or in any other way. In your report under Section 110, paragraph 110 of your report, you talk about a number of observations that were creating a strong perception of favoritism towards McKinsey. 110 sub C talks about the inappropriate reevaluation of bids, resulting in McKinsey deemed the only compliant bidder and awarding the contract. To an individual parliamentarian with some legal background, I view this as taking an original contract of so many different qualities to that contract and manipulating the contract so that McKinsey, in essence, becomes the successful bidder. In my opinion, sir, as a former Crown attorney, a case could be made out for an element of forgery in relation to that practice. Would you agree with that, sir, that could be the subject of an RCMP investigation?
Mr. Chair, so I can't definitively answer yes or no to the question because the fact set is a little bit more complicated than what's kind of portrayed here. So essentially, why we made a negative inference in this specific circumstances, this specific file had documentation at all steps of the process except for the point in time that this is identified where the decision of the evaluation committee was sent to the contracting authority. The contracting authority performed the financial evaluations. The results of the financial evaluations were then made known to all the evaluators. It was at this point in time that one of the evaluators saw who the ultimate winning proposal should be. Now, at that point in time, there's no further documentation as to what happened. Ultimately, it was indicated by that specific evaluator that there had been an error in the assessment of one of the criteria associated as part of the technical evaluation. In their opinion.
Which could in essence be a material, a material alteration of that particular term. So I'm not asking you to agree with me. I'm just saying, could a case be made out, sir, for investigation? In much the same way you agree with me with respect to fraud.
Right. So
right. Okay, I'll move on. I understand your office is also investigating the concept of bait and switch across all federal departments. Is that correct?
So, Mr. Chair, just to clarify, that was reported to the committee that it's something we found reasonable grounds for. As you'll remember, it is a funding issue for our office, so I have put forward a funding request to the department. So pending funding, yes, that is something that we intend to pursue.
If you pursue it, if you undertake it, that in of itself could reveal criminality, correct?
Potentially.
Right. And if you do receive the funding and the approval to proceed, would the bait and switch investigation also include, in these circumstances, McKinsey, in much the same way you investigated the Government of Canada strategies?
So, Mr. Chair, I think it is possible that McKinsey contracts are captured by the bait and switch now.
Thank you.
Okay.
Thank you. In your review of the McKinsey contracts with the Government of Canada, did you uncover any evidence of the destruction of documentation that was prevalent throughout the GC strategy investigation?
Mr. Chair, so we didn't see a prevalence of document destruction. We did see, as you noted, that same file where there was an offer to delete a document associated with the financial evaluation, but that would be the only example that I could think of.
I quickly want to get one question out. You talk about a lack of oversight, particularly by the PSPC. Are you in a position to file at a later date all of the individuals who worked at PSPC and CBSA, in fact, all the departments that you reviewed, who were responsible for their involvement with McKinsey and allowing this misuse of taxpayer funds to occur? Can you give us all the names, sir, within those departments?
So, Mr. Chair, what I can do is I can provide you the names that were captured in the documentation that was provided to us.
Thank you.
How nimble can government be if it doesn't rely on some of these contractors?
So, Mr. Chair, I think you underscored a great point, which is the importance of training public service officials. And I will say that recently I've personally encountered two training programs that I think are particularly strong within PSPC and also within D&D. So they have a 1 and 4 year training program for procurement officials where they can participate actively in experimental training. They get insight into a variety of different transactions early on in their career. So I see that as a seminally important thing. And so training of public servants in procurement is incredibly important.
Agreed. And I hope I have some more time.
No. You're past your time, I'm afraid. Mr. Genois, please.
Thank you, Chair. So we've established that this government had a structural favoritism for McKinsey in terms of their contracting. That exists in a context where, and when we've discussed it at this committee, some of the real horrific abuses that have happened at the hands of McKinsey, advice related to supercharging the opioid crisis, advice on how to identify influential dissidents of the Saudi regime, some of the state-owned companies in the PRC that McKinsey did work for, continuing work for the government of Russia following the initial invasion of Ukraine in 2014, advising employees about not participating, for instance, in pro-democracy activities in Russia. So there's many of these different issues. And so I'm grappling with this reality of deeply unethical behavior by McKinsey, and at the same time how they were favored by the Government of Canada. Did you look at all at sort of the relationship between ethical conduct and favoritism for a company? It's one thing for a company for decisions to be made about a company being excluded or not, and it's a whole other thing about the company that behaves in the way McKinsey does actually being favored by the Government of Canada.
So, Mr. Chair, none of the lines of inquiry actually looked at the ethical behaviors of McKinsey.
Okay, could you comment then on the integrity regime system in particular? Do you think there should be a blacklist? Do you think there could or should be a process whereby, in the context of procurement, officials are looking at the nature of the company they're dealing with and whether it has the kind of values that we would actually want informing advice in government. Do you think that's something that could or should be built into a procurement process?
Mr. Chair, absolutely. I support an integrity and a strong integrity regime where that is something that's contemplated. It also goes hand in hand, and I hate to sound like a broken record today, but it goes hand in hand with the vendor performance management framework as well, because the regime that you refer to kind of speaks to criminal investigations and ultimately convictions and what the implications would be to those suppliers. What I'm talking about is even more broad, is that if, for example, a company promises to deliver something by a certain date and doesn't deliver, I would still argue there's an ethical component to that. And where they haven't delivered, there should be a consequence to them. So I support what you're suggesting.
Thank you. And of course, you're looking at the government of Canada, not at McKinsey. So you're not evaluating their ethical conduct. You're evaluating the government's approach to procurement. Were people in government asking these kinds of questions about McKinsey? Was that sort of part of the thought process or the deliberation that was happening, or was that not on the table or on the radar screen at all?
So I'll answer to the best of my knowledge, and I'll ask Derek as well. But to my knowledge, we didn't see anything in the documentation speaking to the ethics of McKinsey and Co. But I'll let Derek confirm.
I agree.
Thank you, Chair. And I'm going to use the balance of my time now to move a motion that I put on notice with respect to EV battery manufacturing facilities. I believe that you have that. It's the first motion I put on notice.